Welcome and thank you for joining part 3 of Seyfarth's micro-webinar series, Recent Legislative Developments Affecting Washington, D.C. Employers. All participants are in listen-only mode. You are encouraged to submit questions throughout the program using the Q&A feature in WebEx. However, if your question is not answered, our presenters will follow up with you directly in the days ahead. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees following the presentation. At this time, I'd like to turn the program over to Sam Brooks. Sam, you may begin.
Thank you so much, Dave. Thank you to everybody for being with us this afternoon. If you could go to the next slide, please, Dave. Next, please. So today our agenda is pretty straightforward. We are going to talk about the 2023 legislative updates for DC, Maryland, and Virginia. Next slide, please. So for DC, we have a bunch of stuff to cover, and here is the overview of the developments since really late 2022 for those that went into effect into early 2023. And those are the DC Human Rights Act amendments, DC Paid Family Leave updates, employment protections for cannabis use, the Tipped Wage Workers Fairness Amendment Act, Initiative 82, the DC Second Chance Amendment Act, protections for employee reproductive health decisions, and the DC ban on non-competes, which we'll address in turn now. Next slide, please. So first, let's talk about the DC Human Rights Act amendment. As I'm sure many of you know, the DC Human Rights Act is the DC anti-discrimination statute that applies to employers among other entities. The first big change that came in late 2022 was the definition of a covered employee, and the definition has been updated to now specifically include independent contractors, which is a big change. It used to only apply to employees and unpaid interns, and now it applies to independent contractors as well. The amendments also added a new protected class, bringing the grand total to 18. And the newest protected class is homeless status or homelessness, in addition to the sort of traditional protected classes of race, religion, color, etc. There was a new enforcement mechanism that became effective in January 2023, which gave the Office of the Attorney General some additional investigative and enforcement tools, like the ability to file civil actions, much like the EEOC can do, and subpoena power. But I am pleased to report that those enforcement mechanisms expired just a couple of weeks ago on June 8th, and it remains to be seen whether there'll be any activity to renew or re-up those enforcement mechanisms. And the last big change that we'll talk about with respect to the Human Rights Act is a new definition of harassment under the Human Rights Act. Next slide, please. So the new standard under the amendment is the totality of the circumstances, which I'll talk about a bit more in a moment. But historically, DC applied a severe or pervasive standard when evaluating harassment claims. And this is the standard that applies in most jurisdictions because it is the standard under Title VII. And under the severe or pervasive standard, courts look at a pattern of misconduct in the workplace that is either severe or pervasive when they evaluate whether particular conduct constitutes harassment under Title VII. Now, under the DC Human Rights Act, the standard is the totality of the circumstances. And the law now specifically provides that harassment need not be severe or pervasive to constitute harassment, and no specific number of incidents or specific level of egregiousness is required. And this is in direct contrast to the requirement under Title VII that to be actionable harassment, the conduct complained of must be severe or pervasive. Next slide, please. So the law identifies 5 factors to determine whether the conduct constitutes unlawful harassment under the DC Human Rights Act. And those 5 factors include the frequency and duration of the conduct, the location where the conduct occurred, whether the conduct involved slurs, epithets, stereotypes, or humiliating or degrading conduct, and whether a party to the conduct held a position of formal authority or informal power relative to another party. Next slide, please. The law also provides that certain conduct may constitute unlawful harassment regardless of the following circumstances. So regardless of whether the conduct consisted of a single incident. And this is significant because under Title VII, generally, a single incident would be insufficient to constitute actionable harassment under Title VII, unless the single incident was a particularly egregious incident. For example, the use of an historically incredibly offensive word. But now the DC Human Rights Act tells us that it does not matter whether the conduct constitutes a single or multiple incidents. So conduct may also constitute unlawful harassment, regardless of whether the conduct was directed toward a person other than the complainant. So think about an observer who may have witnessed someone else say something or do something to a third party. Conduct may constitute unlawful harassment regardless of whether the complainant submitted to or participated in the conduct. So for this example, think about someone who may have laughed at an offensive joke made about them, or self-deprecated along the lines of the offensive joke to not make a big deal, for example. And now, just because a complainant submitted or participated to the conduct does not mean they do not have an actionable claim. Additionally, if the complainant was able to complete their employment responsibilities, that would not preclude someone from bringing a claim, whether or not the conduct caused, tangible physical or psychological injury, would not preclude someone from bringing a claim. And also significantly, regardless of whether the conduct occurred inside or outside the workplace. And this potentially puts employers on the hook for conduct that occurs outside of the workplace, on the weekends, otherwise outside of business hours, which is a big change. And lastly, the conduct may constitute unlawful harassment regardless of whether the conduct was not overtly directed toward a protected characteristic. Next slide, please. And I should also say, with respect to the DC Human Rights Act amendments, I gave a presentation back in March that went in a bit more in depth into those amendments and the Act in general. And so I would direct you to that presentation, which is available on the website if you're interested in a deeper dive into the DC Human Rights Act. So the next thing I'd like to talk about is the updates to the DC Paid Family Leave, or the Universal Paid Leave Act. As of February 1, 2023, employers were required to post an updated notice, and we have provided the link right there. But again, the compliance date was February 1, so if you have not done that, we suggest you do that right away. And the only other thing to note is that there are no modifications in contribution rates or available benefits for fiscal year 2024. Next slide, please. The next law we're going to talk about is the Cannabis Employment Protections Amendment Act of 2022, which is effective in less than a month on July 13th. And under the act, employers may not refuse to hire, terminate, suspend, fail to promote, demote, or penalize an individual due to an individual's use of cannabis, their status as a medical cannabis program patient, or having the presence of cannabinoid metabolites in their bodily fluids in an employer-required or requested drug test without additional factors indicating impairment. That said, employers may take action in three circumstances. The first is related to the use of cannabis if the employee is working in a safety-sensitive position, if the employee's actions are required by federal statute, federal regulation, or a federal contract or funding agreement, and against employees who are impaired at work and are permitted to require post-accident and reasonable suspicion drug testing of employees. Next slide, please. The Tipped Wage Workers Fairness Amendment Act is making a bit of noise in DC, and this requires employers to file reports of sexual harassment complaints and copies of sexual harassment policies for the years 2020 and 2021 by March 31, 2023, which was a couple of months ago. One thing to flag for you, though, is if the employer has a DC location opening sometime later this year, the employer is required to submit the required documents and certifications within 90 calendar days of opening. We also wanted to flag that if the employer has multiple locations in the district, a separate certification is required for each location. There is also a deadline of August 31, 2023 for sexual harassment training that must be conducted by a certified sexual harassment trainer. And trainers are certified by the DC Office of Human Rights, and it's important that to be compliant, the training not be conducted simply by a educated or well-skilled HR person. It must be someone who is a certified sexual harassment trainer. And we've also provided a link of where you may be able to find some more information about the requirements under the Tipped Wage Workers Fairness Amendment Act. Next slide, please. So let's chat about Initiative 82, which was passed by DC voters in November 2022. And this provides for a gradual phasing out of the DC tip credit and increases the minimum hourly wage until it matches DC's minimum wage, which is currently $16.10 an hour. Effective May 1, the tipped minimum wage was the tipped minimum wage in DC was $6 an hour, and the max allowable tip credit was $10.10 an hour. Given the usual predictable delays in congressional reviews, the DC Council issued revised deadlines, including an increase to $8 an hour effective July 1. Also wanted to flag that as of July 1, the DC minimum wage will increase from $16.10 to $17 an hour for all employers. Next slide, please. The DC Second Chance Amendment Act amends the requirements to seal criminal records, which now includes the automatic sealing for individuals charged with but not convicted of nonviolent crimes. It also shortens the waiting period to seal conviction records and permits employment applicants to indicate a no record response when asked about prior arrests, court appearances, adjudications, or convictions. Criminal records may still be accessed by specific employers, including those that work with children, the elderly, or other special needs populations, which are often the exceptions to the prohibition for accessing criminal records and other records. The law was scheduled to go into effect into March 2023, but will not become operative until its fiscal impact is included in an approved budget, which is always a guessing game on our end, but we will certainly keep you all updated if and when it becomes operative. Next slide, please. Let's now talk about protections for employee reproductive health decisions. So in response to the Dobbs decision, which overturned Roe v. Wade and the constitutional right to abortion, the DC Council passed the Enhancing Reproductive Health Protections Amendment Act of 2022. And generally, this law recognizes the right of every individual to choose or refuse contraception or sterilization, and recognizes the right of every individual who becomes pregnant to decide whether to carry a pregnancy to term, to give birth, or to have an abortion. And relevant to employers, it prohibits employers from penalizing an individual seeking or inducing an abortion or assisting another individual who is seeking or inducing an abortion. An employee who believes that this law has been violated shall have a cause of action for damages as long as it's brought within 2 years of the alleged violation or discovery thereof. And this law was effective February 2023. Next slide, please. Briefly, I'll mention the DC Ban on Non-Compete Agreements Amendment Act. And this law went into effect in October and essentially prohibits non-compete provisions in employment agreements. Specifically, it prohibits employers from imposing non-competes on DC employees who make less than $150,000 per year, or medical specialists who make under $250,000 per year. And employees or workers who make more than $150,000 or $250,000 respectively may have non-competes, but only with certain limitations and only when those workers are notified in advance. And just a little plug for our September 13, 2023, fourth installment of our micro-webinar series. We will go into much, much more detail on the non-compete ban in that presentation. So I would encourage you to attend if you have particular interest in that. Next slide, please. So a few employer takeaways based on what we've talked about so far. The first is to consider how the amendments to the Human Rights Act impact your contracts with independent contractors. Consider updating your anti-harassment policies and harassment training to see how you might have to adjust or revise or amend to deal with these new provisions and what we expect to be a much lower standard to prove harassment than previously. The third thing is to ensure compliance with the updated DCPFL posting and notice requirements, and the sexual harassment reporting and training deadlines for the Tips Workers Fairness Amendment Act. The last thing you should do is review your drug testing policies and procedures to comply with the new protections for cannabis in employment, and update any policies and procedures as necessary. So next slide, please. And with that, I will turn it over to Chrissy.
Thanks, Sam. So we've obviously talked about things that are in effect, but because DC has does not have a defined legislative calendar like Virginia and Maryland, there's generally a lot of activity throughout the year, but especially as we prepare for budget season, which we're in now with the Budget Act just recently being approved, and that usually occurs in the summer. So these are employment-based legislation that are pending. Currently, all are in committee and have recently been subject to a public hearing or are scheduled for a public hearing. And so I just wanted to put these on your radar as things to watch, as the legislation continues to move through council review. As you can see here, there's a heavy focus on wages and wage transparency. So one act is the Pay Range Act of 2023. This would prohibit employers from posting a job advertisement without including the maximum and minimum salary or hourly pay. And there is sort of an admonition that it has to be a good faith range as opposed to, $0 to $400,000 or something like that for every posting. So that's similar to laws we've seen in other, states like Colorado, for example, with respect to wage transparency. The Pay Scale and Benefits Disclosure Amendment Act of 2023 is very similar, would permit prospective employees to access the pay scale for a position, as well as receive disclosure of the schedule of benefits. The Fair Wage Amendment Act of 2023 would prohibit employers from using wage history. So for example, to meet minimum or maximum thresholds that are stated for a position, or for requiring an applicant to disclose wage history in order to continue to be considered for a position. And then the last is the Minimum Wage Clarification Amendment Act, which is a little bit different in that it makes clear if you have an employee who works more than 2 hours a week in the District of Columbia, so if you have an employee who works in different jurisdictions, for example, that time worked in the District of Columbia would have to be compensated at the minimum wage rate in DC. So obviously, Maryland, Virginia, and DC have different minimum wage rates. So if you have an employee performing work in each jurisdiction, if this passes, you would have to monitor the hours worked in DC to make sure that the minimum wage is being complied with for those hours. And again, these are all pending under council review and subject to public hearings. So right now we're just watching these and there's nothing to quote do yet as far as a takeaway for policies or postings. Next slide. Okay, so let's talk briefly about Maryland. Maryland, one of the big ticket items last year was the enactment of the Paid Family and Medical Leave Law, also called the Time to Care Act of 2022. It was recently amended in May of 2023. So we'll briefly review both the original act and the amendments that we've seen to the original proposed outline for this program. So this would be a family and medical leave insurance program administered by the Maryland Department of Labor. If you operate in DC, that's similar to how the DC paid family leave operates in that it's administered by a government agency. Employees would have to work at least 680 hours over a 12-month period prior to the leave date in order to be qualified for leave benefits. The qualified reasons are very similar but not identical to those that would qualify for FMLA leave. There is a general cap of 12 weeks of paid leave benefits in any application year. And this was the big change. I think probably the biggest change for employers in the amendments is that there is delayed implementation now. The covered workers can receive benefits starting January 1, 2026. That was previously 2025. And contributions will now be required starting October 1, 2024, whereas prior to the amendment, they were scheduled to start in October 2023. All employers with more than 15 employees, as well as all employees and self-employed individuals, will be required to contribute to the fund. And a covered employee can also satisfy the Act's requirements through a private employer plan. However, the employer must submit that plan to the Department of Labor and Industry in order for it to be approved and to satisfy the obligations under this legislation. Next slide. Some additional notable modifications to the law from the recent amendments. Contribution rates will be set by October 1, 2023. So as you evaluate whether or not to participate in the fund or use a private plan, additional information should be available in October to make those financial decisions. The amendment has now said that it will be a 50-50 split of contribution between employer and employee. It was previously 25% for the employer, so that is an increase in employer contribution. And employees will not be required to contribute more than 1.2% of their wages. The contribution rate will be applied to all wages up to and including the Social Security wage base. And the initial rates, when we see them in 2023, will be in effect from October 2024 until June 2026. So there will be some predictability with respect to anticipated costs for that time. If an employee experiences a qualifying event but elects not to apply for benefits, the employer can still count an FMLA qualifying leave against their maximum duration of leave available under this law. And that's important because employers are often concerned about the extension of leaves through a consecutive running of FMLA employer provided leave and statutorily required leave. So this does assist employers in being able to set parameters around how those absences will count. And employees are not required to exhaust other forms of paid leave. And there was some other certification updates. We expect to see more information in January of 2024 with respect to regulations as to how this will really be operating and the additional details and expectations of employer obligations. So for now, we're just really watching this. And so with respect to the contribution rates and their regulations, so employers can prepare either their private plan or implementing this as part of their policies. Next slide. Okay, so Maryland last year expanded the definition of harassment, and I'm just going to briefly touch on this because it is very similar to what Sam talked about with respect to DC, meaning the severe and pervasive standard has been removed. And now, in addition to the quid pro quo examples that are provided, we are looking again at totality of the circumstances. And that's important, obviously, because it makes it harder to defend against claims and more likely that employees will bring state-based claims as opposed to federal claims in state court, and with the lower standard that makes it more difficult to, say, for example, get summary judgment. So, we don't obviously have any decisions yet applying these standards, but it will be similar across the board in Maryland, DC, and Virginia, actually applying this lower standard for unlawful harassment. Also notable in this area, Maryland enacted a law that went into effect in October that provides for tolling of time limitations for any statutory unlawful employment action while an administrative charge is pending. So that does provide an additional opportunity or time for employees to bring civil actions if they timely file an administrative charge. Next slide. Maryland also passed a state law requiring reasonable accommodations for applicants. This went into effect in October 2022. However, if you are already compliant with the ADA, this will not require any sort of practice or policy change. It simply provides an additional protection under Maryland law. Next slide. Maryland also just passed in May accelerated minimum wage increase. We will now be at $15 an hour in January 2024, and that was previously scheduled to go into effect in 2025 or 2026 based on employer size. So all employers are now subject to the minimum wage of $15 an hour effective in January. I would note if you are operating in Howard County or Montgomery County, they have additional minimum wage rates and timelines that you should be mindful of. Next slide. Okay, so the Maryland employer takeaways, obviously, I think probably the most interesting is monitoring the continual evolution of family and medical leave insurance updates and guidance as you prepare for implementation of those leave programs. Similar to DC, you want to review your anti-harassment policies and training to make sure that there's really a strong focus on prevention, given the low bar now for proving unlawful harassment in any administrative charge brought under Maryland law or any lawsuit. And we want to make sure that your application process and minimum wage are compliant with the recent updates in Maryland law in those areas as well. Next slide. Next slide. Okay, so Virginia, well, first let me talk about minimum wage. So the minimum wage did increase this year, and as you can see, there are scheduled increases for 2025 and 2026. That will require some legislative action to achieve these actual dollar values. Otherwise, the increase will be adjusted with the consumer price index. Next slide. And so this is just, I think, interesting because Virginia was such a hotbed of employment activity not that long ago. And you can see here everything that was introduced but failed in Virginia, which are really the trend topics of, paid family leave, paid sick leave, sexual harassment training, things that we're seeing out of a lot of other states that, failed at various committees. The workplace violence policy requirements was interesting and not as trendy, I would say, but it's good to, I think, know what Virginia doesn't have right now. If you are a Virginia employer and thinking, okay, these other states have it, does Virginia have it? So these are some things that Virginia doesn't have right now because they failed to make it out of legislation. On the enacted list, you can see it's pretty short and nothing sort of groundbreaking. I'll talk about the first three a little bit more. For sub-minimum wage for employees with disabilities, I would just say if you have an employee with disability that you are paying a sub-minimum wage under federal law, to make sure that that wage is compliant now with Virginia law. It's obviously a very niche concern, so we won't spend time talking about that. Next slide. Okay, non-disclosure regarding sexual harassment claims. This is similar to what was already in effect with respect to sexual assault claims that precluded employers from requiring agreement to a non-disclosure or confidentiality agreement as a condition of employment that would conceal sexual assault claims. That has now been expanded to include any claim of sexual harassment. And so obviously that's important when you're looking at employment agreements or any agreements you're asking your employees to sign on a continuing basis. The law was sort of streamlined or narrowed such that it does not include post-termination agreements or severance agreements. So for this change, you're really just looking at those employee agreements that would, you're asking applicants, new hires, and current employees to sign to make sure nothing is aimed at concealing potential claims of sexual harassment. Next slide. Virginia now prohibits the use of employee social security numbers as identification numbers or having them on any sort of employee badge or any derivation of social security numbers. I think a lot of people have come away from using social security numbers as a form of employee identification, but if you are still using any variation of employee social security numbers for this purpose, that needs to be updated before July 1st. There is a civil penalty for each knowing violation of this law, again, starting in July. Next slide. Okay, the last legislation is unpaid organ donor leave, and it applies to employers in Virginia with 50 or more employees that permits 60 business days of unpaid organ donation or 30 business days for bone marrow donation, and will be available to employees under similar circumstances as FMLA, with the service requirement of a 12-month period and 1,250 hours. However, it does not run concurrently with FMLA. Next slide. This is pretty self-explanatory as to the purpose of donor leave. If you have an employee who is seeking organ donation or bone marrow donation leave, you can require a written physician verification of medical necessity and the eligibility of the employee to be a donor in order to qualify for that leave. Next slide. And this law is very similar to a law that went into effect in Maryland a few years ago if you have employees in both locations. And it provides similar rights and protections we generally see as far as the maintenance of the restoration to the same or equivalent position, the maintenance of health benefits and other employee benefits while the employee may be on such leave, and of course, a prohibition on retaliation for taking the leave or making any reports of violations of the leave. Next slide. Okay, so I think we talked about these. I know we're coming up here on time. The takeaways as we went through the laws. I think the primary focus is probably on making sure that if you do use social security numbers as employee identification, that those systems are updated when that law goes into effect on July 1st, and to review employee agreements to make sure that any non-disclosure or confidentiality provisions have an appropriate carve out that would permit or not encompass, I should say, sexual harassment claims. Next slide. Okay, so our CLE code for today is SS, as in Seyfarth Shaw, 9457. So that's SS 9457. And we really appreciate everyone's time today. Thank you very much.
I just want to chime in real quick for about 15 seconds. I want to answer the one question that was posed about the DC Employment Protections on Cannabis Act. I was not clear in my comments, and I apologize for that. I did a quick check, and the law is still unfunded. So we will wait for funding and follow up with folks when the law will actually become effective. But apologize that I was not unclear. But yes, thank you, everyone, for coming.